Good evening, everyone. I welcome to our AOR Aspirants Academy. This is our 14th lecture series, falling on 14th November 2024 on the Children's Day. I wish you a happy Children's Day first. And what is the message while celebrating this Children's Day? The message is when you go to a school and the teachers wish the children and they provide chocolates and many other small gifts to make a child happy. But how to be happy ourselves? That is the question. To make ourselves happy, we should adopt one motto. The motto is our beauty is duty, our duty is our beauty. Because without duty, we don't have right to claim our rights. We should discharge our duties, we should understand our duties. That duty should be our beauty and added advantage to our life. If we look at the history, our forefathers, like father of our nation, Mahatma Gandhiji, Pandit Jawaharlal Nehru, whose birthday is being celebrated, a first Prime Minister of our country, Sardar Vallabhbhai Patel, Dr. B.R. Ambedkar, and many other leaders who all belong to this profession. And they took the lead, leading the nation in national struggle, freedom struggle, to show the path for the common citizens. So we have to learn the history. To make history, we have to imbibe those great qualities. What is the great quality which you find in abundance with our forefathers? Public interest prevailed over their self-interest, because they wanted that by sacrificing themselves, they thought our country will prosper. So they have lost their practice, they have lost their peace in their family. They are not, the leaders are not in a position to give adequate time to their children, but they gave the blood, they gave their sweat, they gave their entire life to this nation for the Indian independence. When Netaji Subhash Chandra Bose, he made a request to all the youngsters to join his army. But in consideration, he said, I can give you only death. I can fasten your death. I can seek you blood for the independence of our country. So it was not an easy journey or a safe journey to achieve what we are today. So we have to realize the struggles undergone by our forefathers, and we are in digital India, but still our India has to progress in many aspects. What is our contribution? As a lawyer, what is our contribution? We can take care of the interest of the litigants, number one. Number two, what is the contribution for the evolution of law? Whenever we deal with a case, we have to see what could be the evolution for the betterment of others, how to make a case law to be a leading case law. And then is there any public issues to be addressed? Then we can file public interest litigations. So through this process, whatever the contribution, a small contribution can be made by an advocate, we can play the role. So that is what we generally say, have your good heart, make your start, and don't hesitate to play your part. You cannot say what the country has done to me. We have to ask ourselves what we can do for this country. That is important. So with this note, a happy note on Children's Day, let us proceed for today's topic, that is Article 134 of the Constitution of India. On 13th lecture, we have dealt with this topic, an overview about Article 134. But some of our guest attendees, those who have not attended 13th lecture, let me give a recap. What is about Article 134? First and foremost, dear friends, whenever you go, you start preparing yourself, you ask this question, why should I prepare this? Why should I write an advocate on record examination? Or why should I, this is a new case, why should I prepare the SLP in this case? Ask yourself this question. You will find, you will try to find out an answer. Then you will get convinced with your work. Without application of mind, when we start doing it mechanically, that will not lead us to a right path. We may get bored in that journey. So you ask a right question. Question should also be a right question. You should not ask a wrong question, then you will find a wrong answer. So ask a right question. What is the purpose of Article 134 of the Constitution of India? Article 134 of the Constitution of India provides that it deals with criminal appellate jurisdiction of the Supreme Court. An appeal shall lie to the Supreme Court. But before that, dear friends, before going detail into the topic, our everyday routine is reciting the preamble. That is most important. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. This should be our everyday prayer, and we should always ask this question, how to achieve these goals? What am I doing to achieve these goals embedded in the preamble? You will find an answer to yourself. So now let me move on to the topic, Article 134, a criminal appellate jurisdiction of the Supreme Court. Let me give a brief introduction about this. Article 134 deals with two clauses, Clause 1, Article 134 Clause 1 and Clause 2. Under 134 Clause 1, it has got subclauses A, B and C. So this is the structure of Article 134. Now let me move into Article 134. An appeal, it's an appellate jurisdiction, deals with the appellate jurisdiction of the Supreme Court in criminal matters. An appeal shall lie to the Supreme Court. From where? From any judgment, final order or sentence. In which proceedings? In a criminal proceedings. From where? From High Court, passed by the High Court in the territory of India. If there is a rider attached to it, if the High Court, now I am moving on to subclause A. If the High Court reversed the acquittal and convicted him and sentenced him to death. So the High Court, where the High Court has reversed the acquittal and convicted a person and sentenced him to death, there an appeal shall lie to the Supreme Court. Because Sessions Court has acquitted him, has given a complete acquittal. When the state government prefers an appeal to the High Court, the High Court is acting as an first appellate court. There, the Honorable High Court has taken a completely contradictory view, found him guilty for the offence and sentenced him to death. So Sessions Court says acquittal, High Court says convict him and sentence him to death. So therefore it requires a consideration by the Honorable Supreme Court, because it is the case is about life or death of a person. Therefore, it has to be considered by the Supreme Court. So, it's a criminal appeal. Coming to subclause B, where the High Court has withdrawn a case or withdrawn a trial pending before the court, any court subordinate to it, maybe any district courts where a trial is pending, the Honorable High Court has withdrawn the trial and it tried on its own and convicted him and sentenced him to death. So when a case is pending before a particular court, sessions court, any court, you can take any district courts, when a case is pending there, the trial is withdrawn by the High Court, Delhi High Court. I'm just giving an example, it may be any High Court. And the High Court itself conducts the trial and sentences him to, convicts him and sentences him to death. So therefore, the Honorable High Court in subclause B acted as a trial court because it has conducted its trial. So the appeal lies to the Supreme Court because again, it is revolving around the life and death of a person. Now coming to subclause C, this says a certificate has to be issued by the Honorable High Court under Article 134 capital A, certifying that it is a fit case, to be decided by the Honorable Supreme Court. That certificate has to be given by the High Court saying that it is a fit case to be decided by the Honorable Supreme Court. So now we have covered successfully 134 clause 1 A, B and C. Now moving on to 134 clause 2, which empowers the Parliament, to make a law, to further empower the Honorable Supreme Court, give more power to the Honorable Supreme Court and then provide an appeal to the Supreme Court. By virtue of this power, Supreme Court Enlargement of Appellate Jurisdiction Act 1970 was enacted. Thereby, the scope of the Honorable Supreme Court in criminal matters were enlarged. I will be discussing it in detail now. Similarly, there is a section under 420 of BNSS, 379 of CRPC. It is also appeal lies to the Supreme Court in similar lines as that of Supreme Court Enlargement of Criminal Appellate Jurisdiction. So now overall we have seen what is the provision of Article 134. Now let me read, dear friends. Article 134, Appellate Jurisdiction of the Supreme Court in regard to criminal matters. Clause 1. An appeal shall lie to the Supreme Court from any judgment, final order or sentence in a criminal proceeding of a High Court in the territory of India. If the High Court, there is a rider attached to it, if the High Court, subclause A, has on appeal reversed an order of acquittal of an accused person and sentenced him to death. Subclause B has withdrawn for trial before itself any case from any court subordinate to its authority and has in such trial convicted the accused person and sentenced him to death. Or subclause C certifies under Article 134 capital A that the case is a fit one for appeal for the Supreme Court, provided that there is a rider attached with respect to the certificate, provided that an appeal under subclause C shall lie subject to such provisions as may be made in that behalf under clause 1 of Article 145 and to such conditions as the High Court may establish or require. Now, moving on to 134 clause 2, Parliament may by law confer on the Supreme Court any further powers to entertain and hear appeals from any judgment, final order, or sentence in a criminal proceeding of a High Court in the territory of India, subject to such conditions and limitations as may be specified in such law. So, this is the entire provision of Article 134. Now, let me take you to step by step with respect to what is the meaning of judgment, what is the meaning of final order, what is sentence means, what is the reversal of acquittal. These are all the key provisions, key words used in the Article 134. What is acquittal means, reversal of acquittal. Thereafter, when the Parliament is empowered, which act was enacted and what are the provisions, how the Supreme Court's power is enlarged by the Supreme Court Enlargement of Appellate Jurisdiction Act, and what is the limitation to file this criminal appeal. So, we will be discussing it in detail. Now, let me take you to the meaning of judgment, final order, or sentence. Very, very important. We feel that it is very easy to understand, but if you go in depth, there are certain ambiguities with respect to what is final order, what is interlocutory order, which order can be treated as a final order. So, the matter went up to the Supreme Court to determine what is final order or an interlocutory order, that I will be discussing with you with respect to the case laws are concerned. First and foremost, the word judgment, final order, or sentence used in Article 134 of the Constitution of India are similar to those used in Section 205 of Government of India Act 1935. The Federal Court had various opportunities to interpret the term judgment, final order, or sentence, and the courts in India, including the Supreme Court, have by and large followed the interpretation given by the Federal Court. So, the Federal Court had the opportunity to discuss what is final judgment, what is final order, what is judgment. Those Federal Courts' judgment is being followed by our Indian courts, that is Supreme Courts, have adopted it. These words acquire significance for grant of certificate under Article 134 clause 1c. Now they are referring to one important case in Hari Ram Singh versus Emperor. Hari Ram Singh versus Emperor. It was reported in AIR 1939 FC Federal Court 43, page number 43. So in this case, they have interpreted what is judgment and what is final order. Judgment in the code means a judgment of conviction or acquittal. Whether a particular person is accused of some charges, whether he is acquitted or he is convicted. That is the judgment. The term judgment does not include an interlocutory order, because interlocutory order will not determine who is the accused, whether the person is innocent or he is found guilty. Interlocutory order will not find that. It's only the judgment will give a finding whether he is innocent or he is found guilty. So the term judgment does not include an interlocutory order. Hence, the order of High Court directing a rehearing of a criminal appeal by the Sessions Court is not a judgment within the meaning of Section 205. For example, when the Appellate Court, when the High Court, Honorable High Court, referring the matter back to the trial court to refresh, to rehear the matter for fresh trial. So whether that judgment, would it amount to a judgment or a final order? The answer is no, it is not a judgment. Reason is nobody's right or obligations are given any finding. There is no finding whether he is innocent, or there is no finding by the High Court that he is found guilty. It is a matter remanded to the Sessions Court to conduct the trial once again. So therefore it will not fall within the term judgment. Is it clear? Now moving on to the final order. This is very, very important. The word final order are ordinarily used in contrast with the interlocutory orders. If the effect of the order from which it is sought to appeal is not to dispose of finally the rights of the parties, then even though it decides an important and even a vital issue in this case, it leaves the suit alive and provides for its trial in the ordinary way. As the final order may be either in civil or criminal case, the definition given by the lordships in the civil case must by analogy apply to a criminal case as well. So what they are saying is, final order means it must determine, they have taken the definition of the final order from the civil cases, and whatever the interpretations given to the final order in civil cases will be applicable to the criminal cases also. So in civil cases, if a case suit is filed, the decision, if they say plaintiff is entitled to the property or plaintiff is not entitled to the property, so they are deciding the rights and liabilities of the parties. So therefore there is some conclusive with respect to the findings are concerned. So therefore it is a final order, and there is no other issues kept alive. That is very, very important. If only partly issues are decided, when remaining there are certain issues, then it will not fall under the definition final order. So final order means it should finally decide the rights and obligations of the parties, and then there should not be any other issues left out for the determination by the court. So this is a final order, and this definition is equally applicable to the criminal cases also. Now let me take you to one case law that is very, very important case. State of UP, State of Uttar Pradesh versus Colonel Sujan Singh and others. State of Uttar Pradesh versus Colonel Sujan Singh and others. It got reported in 1964, volume 7 SCR, Supreme Court Reports, page number 734. I repeat, 1964, volume 7, Supreme Court Reports, SCR, 734. What is the case is all about? Let me give you a brief facts about this case, and then I will take you to the relevant portions. In this case, Sujan Singh and others were charged for the offence of corruption under the Prevention of Corruption Act. And the case was pending before the Sessions Court, special judge. There, the accused are taking a plea that we are being charged under the Prevention of Corruption Act, and the state government has also obtained the sanction for initiation of proceedings against us. That sanction is bad in law. Court is asking how it is bad in law. The sanction is bad in law because the records, because the authorities must, before giving the sanction, must go through the records, and then only they can come to the conclusion, yes, sanction can be granted. So according to the accused, there is nothing on record. Therefore, the authorities did not peruse the record properly. If they have perused the record properly, they could not have given the approval, sanction. for initiation of the proceedings. Therefore, they said it is bad in law. To prove their contention, they moved an application for production of those documents. So, in a pending case, they have accused have moved an application for production of those documents to support their case that the sanctioning authority has not applied their mind. Therefore, non-application of mind will vitiate. The sanction is bad in law. Therefore, it will vitiate the entire proceedings. So, to support this, they have applied for an application for summoning of those records. But the objection was taken by the state of Uttar Pradesh, saying that it is a confidential document. It is a privileged document. But one crucial point here, dear friends, he is not asking the records from the state of UP department. He is asking those documents from the central government. Though central government is not a party here. The central government was never made a party here. But state of Uttar Pradesh is taking a plea that these documents are confidential documents, privileged documents, we will not give. But the Honorable Sessions Judge said it is not a privileged document, you must give it to the accused. So that was the order. Now who is aggrieved? State of Uttar Pradesh is aggrieved. They don't want to comply with the order. They went in revision before the Honorable High Court. The Honorable High Court also held, by confirming the order of the Sessions Court. The Honorable High Court has held that it is not a privileged document. I do not agree with the contention advanced by the state government. You please provide those documents to the accused. This was the order passed by the High Court. Now they are applying for a certificate. State of Uttar Pradesh is asking for a certificate under Article 134, Clause 1, Subclause C. Please certify that it is a fit case to be decided by the Supreme Court. But the Honorable High Court declined to grant certificate on the ground that this is only an interlocutory order. It is not a final order. I have not decided that he is the innocent or he is the guilty of the offense. It is just a production of a document, a procedural aspect. What is there need to be decided by the Honorable Supreme Court. So the Honorable High Court refused to grant any certificate. Now, again, state of UP is not satisfied. They have went on SLP. By way of SLP, they have approached the Honorable Supreme Court. The question before the Honorable Supreme Court was whether the order allowing to provide those documents to the accused, is it a final order or an interlocutory order? Whether the Honorable High Court was rightly refusing to grant a certificate to the state of UP. So this was the issue before the Honorable Supreme Court. The Honorable Supreme Court has held, first and foremost is, they are asking the documents from the central government, whereas the central government is neither a party before the Sessions Court nor before a High Court, or they were not made as a party before the Supreme Court also. Now, therefore, they have not approached, they have not preferred any appeal. It doesn't mean that interlocutory order will become a final order. So interlocutory order will remain as an interlocutory order. Number two, it is not deciding anything on the offense. They have not given any conclusive finding. It is a procedural aspect. Therefore, the interlocutory order cannot be treated as a final order. So this was the discussion with respect to this case. Now let me take you to the relevant portions. The respondents, that is Colonel Sujan Singh and others, were prosecuted in the court of the special judge after obtaining the sanction of the central government. The point to be noted, central government, not the state government. After obtaining the sanction of the central government for an offence under section 6 clause 1 subclause A of the Prevention of Corruption Act, they put an objection that the sanctioning authority did not apply his mind properly when sanction was granted. One of the respondents asked the court to summon the consent record of the Home Department for it would substantiate his assertion that the concerned officer did not apply his mind earlier in according sanction for his prosecution. The Secretary, Ministry of Home Affairs, claimed privilege. The Special Judge and the High Court in revision rejected the claim of privilege of the Union government. The appellant then filed a petition in the High Court for grant of a certificate. The High Court held that the order sought to be appealed against was an interlocutory one. This is very important. So the High Court held that the order sought to be appealed against was an interlocutory one, and therefore the petition was not maintainable under Article 134 clause 1 subclause C of the Constitution. Against the order of the High Court in revision, the appellant filed a petition for special leave to appeal, stating that he applied for a certificate to the High Court, but it was refused. But what the majority of the decision given by the honorable judges held, the order under appeal was not a final order within the meaning of Article 134 clause 1 of the Constitution. It did not purport to the rights of the parties, namely the state of Uttar Pradesh and the accused, assuming that it decided some rights of the union government. The union government was neither a party to the criminal proceedings, nor was it a party either before the High Court or before this court, that is Supreme Court. The indirect effect of the order of the third party to the proceedings, who did not seek to question that order, did not deprive the order of its interlocutory character. The order ex face was an interlocutory order, and so far as the government of Uttar Pradesh was concerned, it could not possibly be held that any of its rights had been affected by that order. In these circumstances, it must be held that a wrong legal advice is not a sufficient ground for excusing the delay, and the appeal therefore must be dismissed as barred by limitation. Here the SLP was filed with the inordinate delay. SLP was filed with the inordinate delay on the ground that the officers received a wrong legal advice from a lawyer. But that was rejected by the Honorable Supreme Court. Ultimately, the SLP was dismissed. This is the majority decision of this Honorable Court. I would like to quote the judges who are all the party to the judgment. Honorable Justice K. Subbarao, Honorable Justice K.C. Das Gupta, and Honorable Justice Rahubar Dayal. So these are the honorable judges. Though there is a dissenting judgment, I have focused only on the majority view because that is holding the field of law. Now we have seen what is judgment, what is final order. Now what is sentence? Generally, when the Sessions Court imposing a sentence, it has to consider how the offence was committed. Was it brutally committed? What are the aggravating circumstances? And what are the mitigating circumstances? Aggravating circumstances means to what extent to grant a sentence, to order for a sentence, whether how the offence was committed. Was it brutally committed? Or was it made out of sudden provocation? Whether is there one stab or the body was cut into pieces. So these will be considered by the honorable court before imposing a sentence. On the other hand, the mitigating factor is whether he is a first time offender, whether is it a first time or he is habitual offender. What is his family background? Is he an educated person, uneducated person? So whether he is the sole breadwinner of the family, who are all the dependents, whether should we give him the death sentence or the life sentence or reduce it to 10 years. So everything has to be considered by the honorable court before imposing a sentence. When the sentence is imposed, generally the honorable Supreme Court will not interfere with the sentence because it is a judicial discretion exercised by the honorable Sessions Court as well as by the High Court. Therefore, the honorable Supreme Court generally will not interfere with the sentence. That is a general rule. When there is a general rule, there are exceptions. What are those exceptions under which the honorable Supreme Court will interfere? Number one, when there is a harsh punishment is given, whereas the honorable Supreme Court believes or feels that the lesser punishment ought to have been given, but harsh punishment is given. In such a scenario, the Supreme Court will interfere and reduce the sentence. In yet another situation, the lesser sentence was given, but the honorable Supreme Court feels that there should be a more punishment because of the offense committed, the nature of the offense committed. So they will enhance the sentence also. So let me read, dear friends, interference by the Supreme Court in the matter of sentence. It is the usual practice of the Supreme Court not to interfere in the sentence granted by the High Court. The court may interfere with the sentence only when it is established that the sentence is harsh or unjust on the facts and circumstances of the case. So they are using two terms. When the sentence is harsh, the Supreme Court will interfere with the sentence. When the sentence is unjust, that means unreasonable. So in that situation also, the Supreme Court will interfere. Sometimes, very rarely, the Honorable Supreme Court considers the age of the convict also. Sometimes consideration of age has also occasioned interference if he is 90 years old. So they may consider his ailment, his age also. In Surendra versus State of Uttar Pradesh, the Supreme Court observed that the imposition of sentence was always a matter of discretion unless the court finds that the discretion had been exercised arbitrarily, capriciously, or on unsound principles, or that the Sessions Court or the High Court had not taken into account any relevant factors in imposing the sentence. The court would not be justified in reducing the sentence merely because it feels that a lesser punishment or lesser sentence might well have been imposed. So, whenever the Sessions Court or the High Court exercising their jurisdiction to impose a sentence, it should not be arbitrary in nature. It should not be based on unsound principles, or it should not be based on not taking into the relevant factors, where we call it perversity. When the relevant evidence are there, when you ignore those evidence and then considering the irrelevant facts, leaving the relevant facts, that is perverse. So in such scenario, the Honorable Supreme Court will interfere with this sentence. So now we have seen what is the key provisions, that is what is judgment, what is final order, under what situations, circumstances the Supreme Court will interfere in sentence also. Now let me take you to Article 134, Clause 1, Subclause A. What does it say? the High Court reverses the order of the acquittal, and the accused person, he is found him guilty and then imposing a death sentence. The most important aspect, the key provision, key words in Article 134, Clause 1, Subclause A is reversal of acquittal. What does it mean? Reversal of acquittal means, generally, in common parlance, even among the lawyers community also, we feel acquittal means, for example, A is charged. The person A is charged for the offense of murder. The prosecution produces the witnesses, accused also produces the witnesses. After trial, the Sessions Court comes to a conclusion that the prosecution has failed in its duty to prove its case beyond reasonable doubt. Therefore, he is acquitted. So, it is a clean acquittal. Though benefit of doubt is given, he is acquitted, he is released from the jail. State of any state who is aggrieved prefers an appeal to the Honorable High Court, and then the Honorable High Court reversing the order of acquittal and sentencing him to death, and criminal appeal will lie to the Supreme Court. This is understandable. I have come across few cases. There is a reported judgment also. I will be reading it very shortly, where an accused was charged for the offense under section 302 for the offense of murder. Trial is going on. The Sessions Court delivered a judgment saying that there are not enough materials to punish him under 302, but I will punish him under 304 part 1, culpable homicide not amounting to murder part 1, and imposed only 3 years punishment, fine of rupees 100. It is a old judgment. Now the state government is aggrieved. The state government felt he should be punished for the murder and he should get either life sentence or the death sentence, but here the Sessions Court has found him guilty under 304 part 1. Therefore, they have preferred an appeal. State government went on appeal to the High Court. Now High Court reversed the order of acquittal under section 302. It is not acquittal, it is acquittal under 302, and they have convicted him under 302 and punished him to death. Now the aggrieved person prefers a criminal appeal under Article 134 Clause 1 Subclause A, saying that High Court has reversed the order of acquittal under section 302. Now the question arose, what is the meaning of acquittal? Whether acquittal means a complete acquittal or acquittal under 302, punishing him under 304, but on appeal, the High Court punished him under 302 and putting him under death sentence. Would it also amount to reversal of acquittal as prescribed under Article 134 Clause 1 Subclause A? A very beautiful judgment. The honorable judges, in their wisdom, they have interpreted what is the meaning of acquittal. Let me take you to the relevant portion, relevant judgment. The name of the case is Tara Chand Damu Sutar. Tara Chand Damu Sutar versus the state of Maharashtra. It is a constitution bench judgment. When 5 judges are constituted, for what purpose? When there is a very, very important, substantial question of law as to the interpretation of the constitution, or as to the great importance which have a huge ramifications in our country, constitution bench are constituted. Here, This case, it was reported in 1962, volume 2 SCR, page number 775. 1962, volume 2 SCR, page 775. Let us remember our lords who has delivered this judgment also. Honorable Justice J.L. Kapoor, Honorable Justice K. Subbarao, Honorable Justice M. Hidayatullah, Honorable Justice J.C. Shah, and Honorable Justice Rahubar Dayat. These are all the 5 learned judges who has delivered this judgment. Let me give you the brief facts. The appellant, that is Tarachand, was tried for an offence under section 302 Indian Penal Code for the murder of his wife. The evidence consisted mainly of the uncorroborated dying declaration of the wife. Wife gives a dying declaration saying that he has caused the injuries, and it was not corroborated, it is uncorroborated. The evidence consisted mainly of the uncorroborated dying declaration of the wife. The sessions judge accepted the evidence but convicted the appellant under section 304 part 1 Indian Penal Code. And what is the punishment that he imposed? He imposed 3 years rigorous imprisonment and a fine of ₹100. So 3 years rigorous imprisonment and fine of ₹100. Thereafter, on appeal filed by the state, the High Court convicted the appellant of an offence under section 302 of Indian Penal Code and sentenced him to death. So High Court punishes him under 302 and sentences him to death. The appellant contended, Tarachand contended, that he had a right of appeal to the Supreme Court under Article 134 Clause 1 Subclause A of the Constitution, and that his conviction was bad. But the Honorable Supreme Court has held that the appellant had a right of appeal to the Supreme Court under Article 134 Clause 1A of the Constitution. They have said, yes, the accused has a right to prefer an appeal under Article 134 Clause 1A of the Constitution. The conviction of the appellant under Section 304 Part 1 of IPC by the session judge amounted to acquittal. Acquittal under 302, therefore that is also amounted to acquittal. The order of acquittal, I repeat, held that the appellant had a right of appeal to the Supreme Court under Article 134 Clause 1 Subclause A of the Constitution. The conviction of the appellant under Section 304 Part 1 of the IPC by the session judge amounted to an acquittal of an offence under Section 302, and the High Court had reversed this order of acquittal and sentenced the appellant to death. The word acquittal, now they are interpreting. The word acquittal in Article 134 Clause 1 Subclause A did not mean that the trial must have ended in a complete acquittal of the charge, but acquittal of an offence charged and conviction for a minor offence was included in the word acquittal. See how they are beautifully interpreting the term acquittal. If the High Court reverses an order of acquittal of an accused person and sentences him to death, an appeal shall lie as of right to this court under this article. The argument raised on behalf of the appellant was that the appellant was acquitted of the offence of Section 302 and was convicted under Section 304 Part 1. It was a case of reversing an order of acquittal. The argument on behalf of the state was that the word acquittal means a complete acquittal. That is what the state government took a plea. The argument on behalf of the state was that the word acquittal meant complete acquittal. The decision of this must depend upon the construction of the word acquittal. If a person is acquitted of the offense charged and is convicted of a lesser offense, as in the present case, can it be said that he was acquitted and the High Court had an appeal reverse the order of acquittal? In our opinion, now the Honorable Judge is giving an opinion. In our opinion, the word acquittal does not mean that the trial must have ended in a complete acquittal of the charge, but acquittal of the offense charged and the conviction for a minor offense than that for which the accused was tried is included in the word acquittal. Now they have given the opinion. Further, they are taking support from where? This view has the support of a judgment of the Judicial Committee of the Privy Council. They are referring to the President in Kishan Singh versus the King Emperor. In that case, an accused person was tried by the session judge under 302 of Indian Penal Code on a charge of murder, but was convicted under 304 for culpable homicide not amounting to murder, the code having power to do so under section 238 clause 2 of the Criminal Procedure Code. He was sentenced to 5 years rigorous imprisonment. No acquittal of the charge under section 302 was recorded. There was no appeal to the High Court by the then local government, but it applied for revision under section 439 on the grounds that the appellant should have been convicted for murder and the sentence was inadequate. The High Court convicted the appellant of murder and sentenced him to death. On appeal to the Privy Council, it was held that the finding of the trial court was to be regarded as an acquittal on the charge of murder, and that under section 439 clause 4 of Criminal Procedure Code, the word acquittal did not mean a complete acquittal. So this is how they have beautifully interpreted the term reversal of the acquittal. Now moving on to certificate issued by the Honorable High Court, saying that it is a fit case to be decided by the Supreme Court. What are the parameters under which the High Court can grant a certificate? They may have the power, the High Court may have the power, but in which case it has to be exercised, that is most important. It is not a general practice that every case that the Honorable High Court will issue a certificate, but only in proper case, only in a fit case, that the Honorable High Court will give a certificate. What are those parameters? Now I will read that. Principles to be followed in granting certificate under Article 134 Clause 1 Subclause C. The provision of Article 134 Clause 1 Subclause C gives power to a High Court to grant certificate in case it is a fit case for appeal to the Supreme Court. It should be a fit case. In the state of Bihar versus Bhagirath Sharma, it is reported in 1973, volume 2 SEC, page number 257. The court held as follows. The word certify in this article, as often observed by this court, is a strong word postulating the exercise of judicial discretion in determining if the question requiring decision by this court involves a matter of principle or a substantial question of law of great general importance. Dear friends, please make a note that involves a matter of principle of law or a substantial question of law. It is not mere question of law. It should be a substantial question of law to qualify the test that it is a fit case. Or of general importance, a substantial question of law of general importance. Such certificate is not to be given as a matter of course on the mere ground that the impugned decision is considered to be erroneous. If the impugned decision is erroneous, as a matter of fact, the High Court will not issue a certificate unless and until it involves a substantial question of law of general importance. There must be exceptional or special circumstances. So what are those special circumstances under which a certificate can be issued? The special circumstances is number 1, infringement of essential principles of justice. Infringement, violation of the essential means fundamental principles of law, that is ignored or violated, then a certificate can be given. Or some difficult question of law of great public or private importance. The Supreme Court has, over the years, laid down some parameters for the exercise of power under the subclause. Generally, a certificate will not be issued if there is a concurrent finding. A Sessions Court also given a judgment, and the High Court also has affirmed the judgment. When two courts has given, the High Court will not generally give a certificate that it is a fit case to be decided by the Supreme Court. Where by a disregard of the forms of legal process or by a violation of principles of natural justice or otherwise a substantial and grave injustice, it is not mere injustice, it is a grave injustice has been done, special circumstances will undoubtedly exist for a grant of certificate. So in the question of fact, certificate will not be issued. In the question of law, certificate will not be issued, but in the substantial question of law of general importance, certificate will be issued. So similarly, where the question of outstanding difficulty or importance arises, which the High Court considers should be resolved by the Supreme Court, the certificate may be granted. Even mere questions of law or principle should not suffice. The question of law or principle should be of outstanding importance or difficulty so as to require to be decided by the Supreme Court. In a question only of facts, whether certificate can be issued, the answer is no. In a question only of facts, High Court is not entitled to grant a certificate under Article 134 Clause 1C of the Constitution. So therefore, dear friends, as a matter of practice, just as a matter of course, the Honorable High Court will not grant a certificate. Only under the exceptional circumstances, the Honorable High Court will issue a certificate certifying that it is a fit case to be decided by the Honorable Supreme Court. So what are the parameters to decide that it is a fit case? That there is a fundamental error of law. Fundamental principles of law is violated. When there is a violation of principles of natural justice, when there is a substantial question of law of general importance, or when there is an outstanding difficulty which is not resolved, therefore it is a fit case to be resolved by the Honorable Supreme Court. So under these circumstances, the Honorable High Court will issue a certificate. Now we have successfully covered Article 134 Clause 1A also. B is something where it withdraws its trial from the subordinate court and then it acts as a trial court and convicts the person and sentence him to death. Coming to C, subclause C, a fit case certificate to be issued by the High Court certifying that it is a fit case to be decided by the Supreme Court. That is also covered. Now moving on to subclause 2, Article 134 subclause 2. What does it say? It gives power to the Parliament to make a law to further entrust the power with the Supreme Court. So what is that power? What is that act enacted by the Parliament in enlarging the appellate jurisdiction of the Supreme Court? So by virtue of Article 134 subclause 2, Parliament has enacted a law. What is the name of the statute? It is the Supreme Court Enlargement of Criminal Appellate Jurisdiction Act 1970. It is only very small act. This is only one page containing 2 sections and which discusses about the enlargement. An act to enlarge the appellate jurisdiction of Supreme Court in regard to criminal matters, be it enacted by Parliament in the 21st year of the Republic of India as follows. Section 1, short title and extent. This act may be called the Supreme Court Enlargement of Criminal Appellate Jurisdiction Act 1970. So now let me ask ourselves this question. What is the meaning of enlargement? Enlargement means widening the scope of criminal appellate jurisdiction of Supreme Court. So what is that they have widened the power? Now let us see. Section 2 is the answer to my question. Section 2 of the Supreme Court Enlargement of Criminal Appellate Jurisdiction Act 1970, which deals with enlarged appellate jurisdiction of Supreme Court in regard to criminal matters, without prejudice to the power conferred on the Supreme Court by Clause 1 of Article 134 of the Constitution. So, without prejudice to Article 134, Clause 1, an appeal shall lie to the Supreme Court from any judgment. An appeal shall lie to the Supreme Court from any judgment, final order, or sentence in a criminal proceeding of a High Court in the territory of India, if the High Court, subclause A, has an appeal reversed an order of acquittal of an accused person and sentenced him to imprisonment for life. Please take note of it. Death sentence is covered under Article 134, Clause 1A, but they are enlarging the scope. That is, High Court on appeal reversed an order of acquittal of an accused person and sentenced him to imprisonment for life or to imprisonment for a period of not less than 10 years. Clause B, Section 2, Clause B, has withdrawn for trial before itself any case from any court subordinate to its authority, and has in such trial convicted the accused person and sentenced him to imprisonment for life or to imprisonment for a period of not less than 10 years. So, dear friends, Article 134, Clause 1A, 1B, they talk about reversal of the acquittal and sentences him to death. That is A. B says the High Court acting as a trial court and sentencing him to death. But what about when the Sessions Court convicts when the High Court convicts for the life sentence or for sentence not less than 10 years? Whether appeal will lie to the Supreme Court? The answer is yes, under Section 2 of the Supreme Court Enlargement of Criminal Appellate Jurisdiction. Why? Why this act? Reason is, it is not only the death sentence. Death sentence is a capital sentence. Of course, appeal must lie to the Supreme Court. Apart from that, even the life sentence, even the sentence which are less than 10 years, not less than 10 years. So that means minimum 10 years and more than 10 years. So those also involves the personal liberty of a person, a grave punishment. Therefore, that has to be decided by the Supreme Court, and this is a matter of appeal provided to the accused under Section 2 of Supreme Court Enlargement of Appellate Jurisdiction, Appellate Enlargement of Criminal Appellate Jurisdiction Act 1970. So therefore, they have given a right, extra right to the accused to appeal to the Supreme Court, not only against death sentence, but also against life sentence and sentence not less than 10 years. So enlarged scope is the enlarged heart of the Parliament to provide a right to the accused. In similar lines, dear friends, there is one more provision under CRPC. Just give me a second. This is 420 of BNSS. CRPC, old CRPC provision is 379. Appeal against conviction by High Court in certain cases. Where the High Court, I am talking about old provision, that is 379 of CRPC. Presently it is 420 of BNSS, which deals with appeal against conviction by High Court in certain cases. Where the High Court has on appeal reversed an order of acquittal of an accused person and convicted him and sentenced him to death or to imprisonment for life or imprisonment for a term of 10 years or more, he may appeal to the Supreme Court. This is a provision provided under CRPC. Now 420 of BNSS. Now I would like to touch upon what is the scope of criminal appeal, and then with Article 136 special leave, because it is a power vested with the Honorable Supreme Court to exercise its power under 136 also as well as under 134 also. But the scope of criminal appeal under 134 is broader, is wider than the scope of Supreme Court in under Article 136. Reason is, under Article 136 it is only a substantial question of law. But whereas in criminal appeal, the Honorable Supreme Court can reappreciate the evidence, because it is a criminal appeal as a matter of right. So the Honorable Supreme Court can go into the many aspects than under Article 136. And what is the limitation that you file? Generally, in special leave petitions, we file it within 90 days. But here, the limitation is only 60 days. Period of limitation for making an application for leave to appeal to the Supreme Court under Article 134 Clause 1C by virtue of Article 132 of the Limitation Act. Dear friends, they are talking about the Limitation Act. By virtue of Article 132 of the Limitation Act 1963, the period of 60 days is prescribed for an application for certificate of fitness for appeal to the Supreme Court under Article 134 Clause 1 subclause C from the judgment or order or sentence. Dear friends, now we have covered almost the entire aspects. Let me sum up quickly. So we have seen today, because some of our attendees have come late, therefore this will be helpful for them when you sum up the entire 1 hour session. We have discussed about Article 134 of the Constitution of India, which deals with appellate jurisdiction of the Supreme Court in criminal matters. In Clause 1 it says, an appeal shall lie to the Supreme Court from any judgment or final order or sentence in criminal matters passed by the High Court. There is a rider attached to it if the Honorable High Court reverses the order of acquittal and punishes him and sentences him to death. Appeal lies to the Supreme Court. Clause B, where the Honorable High Court withdraws the trial from any case, from any court subordinate to it, and conducts the trial on its own and sentences him to death. Clause C, that the Honorable High Court can certify that it is a fit case to be decided by the Supreme Court. Clause 2, 134 Clause 2 says, Parliament is empowered to enact a law to enlarge the scope of the Supreme Court in criminal matters. By virtue of that, Supreme Court Enlargement of Criminal Appellate Jurisdiction Act 1970 was enacted. So when I cited this, when I was summing up, you could have seen the world behind the word. When I have said judgment, judgment means conviction or acquittal. Final order means not only mere the production of the document, it is only the procedural order. Therefore, it has not determined conclusively the rights and obligations of the parties. Therefore, summoning of a record is not a final order, it is only an interlocutory order. In sentence, Generally, the Supreme Court do not interfere with the sentence because it is a discretionary power exercised by the Sessions Court as well as by the High Court. However, if it is too harsh, if it is unjust, unreasonable, arbitrary, capricious, then the Supreme Court will interfere with respect to the sentence also. What is order of acquittal? Acquittal means it is not complete acquittal. When a person is punished under 304 part 1, when the High Court convicts him under 302, that is also the reversal of the acquittal. Therefore, an accused can prefer as a matter of right a criminal appeal under provision 134 clause 1 subclause A. Now, thereafter, certificate. When a certificate is to be issued by the High Court, certificate generally will not be issued, but under exceptional circumstances it can be issued. What are those exceptional circumstances? When there is a violation of principles of natural justice, when there is a fundamental error of law, when there is a grave injustice. So on those principles, they will grant certificate. Under what principles they will not grant certificate? When it is a mere question of law, when it is a question of fact, when there are concurrent findings, they generally Honorable High Court decline to grant certificate. Right? This is with respect to the certificate. Now, with respect to the Supreme Court Enlargement of Criminal Appellate Jurisdiction Act is, it is not only the death sentence is covered under 134 clause 1A, therefore it widens the scope of criminal jurisdiction where the High Court reverses the order of acquittal and sentences him to life sentence as well as not less than 10 years, it is a fit case to appeal to the Supreme Court under the Enlargement of Criminal Appellate Jurisdiction. So with this, dear friends, we have seen what is the limitation also, and we have seen what is the scope of 134 and 136 also. So hope it is clear. Once the question comes to you, it depends upon how much mark. If it is 2 marks, you need not write all this. Look at the mark, what is the mark and what is the question that they have asked you. Accordingly, you can answer all these questions. Dear friends, with utmost respect, with utmost humility, I say, AOR advocate on record examination is not a burden. It is a journey, it is a life journey. Because though we have completed more than 10 years as an advocate on record, still we have to read, we have to update ourselves. I take a guidance from one of the retired Chief Justices of India, Honorable Justice Kapadia. I attended his farewell. He said during his farewell function, I am retiring not as a Chief Justice of India, but as a student of law. I have learnt more from the interns, more from the freshers. So therefore, I don't have that ego that I have become a Chief Justice of India, therefore I know everything. Law is ocean. What we have known is only the drop. Therefore, AOR examination, don't treat it as a burden. If you treat it as a burden, it will be a burden for you. Treat it as a journey, it is helping you to equip yourself, making you more knowledgeable. Otherwise, we won't touch these books. So therefore, it is very important, dear friends. And I have my senior associate, Mr. S.K. Patri sir. He has come here. He wants to share his knowledge with you all.
It will boost your image.
Please.
It is a great honor for me to speak on Raja. Raja, because whenever I see Raja is speaking, I always try to come. It is my second meeting with him. But I knew him when he started practicing here in the Supreme Court. He is a great lawyer then and becoming greater day by day. His journey to this profession is also remarkable. I always jokingly say that he came as a prince, became a Raja, and he is going to become Maharaja. Religiously he is doing it free of cost, giving your valuable time, taking his valuable time, whether you become an advocate record or not, whether you become a senior lawyer or not, whether you become a judge of this court or any other court of this land, his journey to, his association with you is remarkable. Remarkable, I tell you. It is a great audience, great people, and you will love it because he has really read the law in a very big way and still reading it and still observing us. And he's like a student also, like me, and he likes me also. So when I knew that he's still speaking, I said I should join in him. And I always tell all my friends, those who are in this profession, those who are in the judicial profession, even in general life also, law is required. So follow Raja, you will become Maharaja. That's mine. I want to inspire him because he is doing a noble job. And you always remain a student, you are a law student, you will remain a law student till death. Maybe after death you can come again as a law. Thank you. God bless you all.